This video clarifies the differences between three types of special needs trusts. Let's start by revisiting the purpose of special needs trusts. A special needs trust, or SNT, essentially serves one purpose: to provide resources to improve or sustain a higher quality of life for someone with special needs without disqualifying that person from means-tested public benefits. Means-tested public benefits are reduced or lost when a special needs individual's income or, in some cases, assets exceed certain limits. Such benefits include Supplemental Security Income, Medicaid, and food benefits. Because SNTs supplement but do not replace benefits, they are also called supplemental need trusts. SNTs come in three basic types. A third party SNT forms when any party other than the person with special needs contributes assets for that person's benefit. A first party SNT forms when the person with special needs receives assets and establishes a trust for himself or herself to avoid losing public benefits. The same special needs person both funds the trust and benefits from it. Pooled trusts provide third parties or persons with special needs an opportunity to establish SNTs by pooling their resources with assets held for many special needs beneficiaries. All types of SNTs follow certain rules. For example, the special needs beneficiary cannot serve as the trustee in charge of the trust, and the trustee cannot pay money directly to the beneficiary. The third party SNT is the most common form of special needs trust. Any third party, that is, anyone other than the special needs beneficiary, can establish and fund a third party SNT. A third party SNT can be set up so multiple parties can contribute to it. For example, a parent may establish an SNT for a special needs child and make an initial contribution. Then grandparents may contribute additional assets. A third party SNT can be inter vivos or testamentary. Testamentary trusts come into existence upon the death of the grantor, usually through the grantor's trust or will. The grantor establishes an inter vivos trust while the grantor is living. Third-party SNTs are essential for special needs families. If you have a special needs child or other beneficiary or heir, this type of trust should be part of your estate plan. The first-party SNT goes by several names that tell us something about this type of trust. The first-party SNT is self-settled because the special needs individual receiving public benefits establishes the trust by transferring assets into it, and the trust is for that individual's sole benefit. The first-party SNT derives the name D4A trust from the section of the Internal Revenue Code that governs the trust. This section provides that the beneficiary of the trust must be under 65 and disabled as defined by the code. This section also requires that any assets remaining in the trust after it terminates, usually by the death of the beneficiary, must be paid back to Medicaid, thereby giving the trust this name, Payback SNT. The first-party SNT must be irrevocable, in part to guarantee that any amounts not distributed to the beneficiary will go to Medicaid. When an individual receiving public benefits suddenly receives a large amount of funds, a first-party SNT can prevent the loss of those public benefits. The funds may come suddenly, for example, from an award in a personal injury case, an inheritance, or a life insurance payout. The beneficiary or someone acting on the beneficiary's behalf, such as a parent, an agent under a power of attorney, or a court, establishes a first-party SNT. Pooled SNTs offer alternatives to both first-party and third-party SNTs, which are costly and complex to establish and administer. Pooled SNTs typically require lower amounts because they pool and invest funds contributed for many beneficiaries. Unlike first-party SNTs, pooled trusts can be established for beneficiaries over 65 years of age. A nonprofit entity manages and administers a pooled trust. Some pooled trusts are local, such as the Jewish Los Angeles Special Needs Trust and the Arc of Texas Master Pooled Trust. Some pooled trusts are nationwide, including the Secured Futures Pooled Special Needs Trust. Each of these pooled trusts serves different populations and has its own set of terms and fees, which are set forth in a joinder agreement. Anyone considering contributing to a pooled SNT should read that joinder agreement carefully. Planning for your loved one with special needs can be intimidating. If you don't plan, however, your loved one may lose access to public benefits when continued access to those benefits are needed most. I'm Daniel Van Slyke, licensed to practice law in Texas, California, and Missouri. Contact me to discuss planning for your special needs loved one. You can find me at iplanlaw.com.